Choosing the path of silence will help your case. Reasons to remain silent. You have the right to remain silent. Why does it sound so familiar? It is the first line of the Miranda rights, which are read to people when they are arrested. It is also the primary way to help your case if you are arrested. Anything can and will be used against you in the court of law. This is perhaps one of the most well-known phrases concerning law enforcement since the Miranda rights were established by the Supreme Court. While various movies and television shows have used it to increase drama, many people in the real world hear these words on a daily basis. Before or during an arrest, it is important to ask oneself whether to utilize their right to remain silent. While law enforcement agents attempting to obtain information from a suspect will encourage friendly conversation, criminal defense attorneys who are looking out for the good of their clients universally agree that silence is golden when it comes to an arrest and interrogation. Despite how much you think that talking to the police can help your case, here are some of the top reasons to remain silent until your legal representative arrives. The slightest variation in your story can hurt you. Even when you tell the truth, it is almost impossible for anyone to tell the same story twice the same exact way. Sharing a testimony before your trial can come back to haunt you during cross-examination when the prosecutors will be seeking to nitpick every detail of your account, word for word. Regardless of how innocent you are or whether you are telling the truth, telling it only once is your safest bet for a stronger defense. This protects you from accusations that you withheld information or changed your story since you last spoke to the police. The police cannot actually grant you leniency for sharing information. While it is a common tactic used by police officers in attempts to gather information from a suspect, the police do not have the authority to give you a deal for sharing information about the case with them. This is often attempted in cases involving more than one suspect, but only one apprehended. Police officers will try to get information about the other suspect from the one they have arrested. While this information will not only be a sign of admission from the apprehended suspect, it also cannot actually guarantee a deal from the prosecutors. It is better to remain silent until your criminal defense lawyer verifies that a legitimate deal is being offered in exchange for the information. Pleading guilty can wait. Even suspects who are guilty and want to admit to the charge should stay quiet until they have received counsel from a legal professional. There may be factors in the case that make it possible to bargain for a lesser charge or even take the chance in court. Either way, hold off on admitting to the crime until your attorney has given you the go-ahead.
Accidental white lies. With nerves frantic and blood rushing, sitting in an interrogation room being questioned by a police officer can impact a person's judgment. Fear of conviction and penalties can lead one to exaggerate or minimize the events of the incident in question. Deviations from the truth, regardless of how innocent the intentions of the suspect were, are always taken as a sign of guilt. Talking will not help you. The very fact that you are being questioned by the police is telling of their intentions to gather information to incriminate you. That means that no amount of information you share with them will cause them to drop the charges or let you go. Many police officers will attempt the good cop strategy, goading you to open up to them and be honest. Even if the honest truth is that you are innocent, your words will do nothing to convince them of that. When someone is arrested, it is because the police think they have enough evidence to convict you of a crime. No one can talk their way out of an arrest, no matter how smart or honest you are. If you have been arrested and are wondering what the next step is, contact your SDF criminal defense lawyer. We want to provide you with the counsel and representation you deserve as you face the charges that have been brought against you.
The Fifth Amendment gives you the right to remain silent. Even if you are caught in what looked like the act of doing something illegal, it is the prosecutor's business to prove that you did it. Also, they can only use evidence they have the right to use. No matter what the police officer says to you, you have a right to not say something that will make your situation worse.
The police must tell you that you have the right to stay silent. You know that you have the right to silence. They know you have the right to silence, but the police officer is legally required to tell you that you have this right. If they don't tell you that you have this right and warn you that what you say can and will be used against you, they might be undermining their ability to use that information in court, unless you speak up, waiving the right to silence, and give them the right to use it.
Posting about your case on social media is the same as waiving the right to silence to the police. What is published on social media sites is public information and could be used in a court case against you. Talking about your case to your friends on Facebook, Twitter, or any other social media site is like going out onto your front yard when the police officer is standing right there and yelling that you did it. They can find the statement and will use it. Don't do it.
When can the police lie to you? Can law enforcement lie to you during an interview? They most certainly can and often do. Therefore, the deeper question we explore here is, when can the police lie to you, and under what circumstances? Further, what steps can you take to protect your rights if the police authorities question you? The U.S. Supreme Court allows the police to use deception techniques, lying, during a criminal investigation. However, there are limits. The police cannot use this powerful psychological ploy to coerce an innocent person to confess to a crime they did not commit. Further, it is unlawful if a statement is obtained from a suspect in a way that violates their legal rights. For example, statements made due to a suspect's psychological mistreatment, with threats or false assurances, confessions elicited without following established rules and principles, misrepresenting a suspect's legal rights.
Why does law enforcement lie during an interview? Defense attorneys often see cases where innocent and guilty people are persuaded to confess due to heavy-handed police interrogation techniques. After all, a police interview is designed to produce confessions. As such, an attending officer may use psychological tactics such as lying as a means to make you feel at ease during an interview, making you more likely to comply with their questioning, compel you to confess to a crime, discredit an alibi, obtain evidence or information that could lead to an arrest. Confessions are the most incriminating and persuasive evidence of guilt that the state can bring against a defendant. The purpose of a defense lawyer is to help shield you from coercive interview techniques while protecting your rights during the interview.
What should you do to protect your legal rights? The best way to avoid incriminating yourself is by saying nothing at all without first talking to your lawyer. This is mainly because talking does not help you. The police are questioning you because they believe you are involved in criminal activity. Anything you say can be used against you but cannot be used for you. There is no rush. You should never feel pressured into giving a statement or answering any questions without being allowed to consult with your lawyer first. Keep in mind, even if you have already answered some questions, you can calmly invoke your right to remain silent at any point during the interview and request to speak to an attorney.
What can the police lie to you about? Evidence against you. We have your fingerprints at the scene of the crime. An investigating officer can make false claims about having obtained evidence. These can include having a witness, DNA, or fingerprints from the crime scene linking you to the offense, even if no such evidence exists. The goal here is to pressure you into talking, perhaps to defend yourself, especially when there may be little or no evidence to support the case against you. Lying about the evidence against a suspect during a criminal investigation is generally accepted by the U.S. Supreme Court. Threats or promises of leniency by the police. If you do not make a statement, you will go to jail. Making a statement will get you a lighter sentence. For a confession to be admissible as evidence, the suspect must make it voluntarily without threats or incentives. The police do not have the authority to promise a shorter sentence or make a deal. Only a prosecutor has the power to do this. It is unlawful for a police officer to coerce you into making a statement by using intimidation or enticements such as those listed above. However, language along the lines of, "I just want to help you out here," is legal. A vague implication suggesting things will be better without being overly specific is acceptable under the law. Recording your conversation. It's okay to tell me what happened. This will be off the record. To encourage you to speak without your lawyer present, an officer may falsely claim you will not be recorded or be on record. Remember, anytime you are questioned, what you say can be used against you in court. Having a confession implicating you from someone else. We already have a confession from your friend about what you did. If you are told someone else has confessed to what happened, it makes sense to consider why the police are still questioning you. But unfortunately, this bluff is often used to persuade you to answer questions that could incriminate you.
What should you do if the police want to question you?
While criminal defense attorneys are generally hired after an arrest, you must understand that even informal questioning could lead to an arrest if you do not protect your rights. If a police officer approaches you at home or on the street, ask if you are being detained. If you are free to leave, then do. If not, say you wish to speak to a lawyer, then remain silent. Remember, an arrest will stay on your record, even if you are acquitted of a crime. This can have serious implications for your personal and professional life, as the details are accessible as public records. Your lawyer may be able to prevent arrests or charges before they happen. If you are arrested, invoking your right to remain silent until your lawyer is present means you do not do or say anything that can be used against you in court at a later date.
In short, the single best thing you can do during a police interview, even if you are innocent of a crime, is remain calm and politely decline to answer any questions without your lawyer present. Let your lawyer speak for you. The police officer must also tell you that you have the right to an attorney, and you do. An experienced criminal defense attorney knows the criminal justice system and can advocate for you. They know what to say, how to say it, and when to say it.
Self-Defense Fund members are protected by award-winning attorneys and their legal teams.